and welcome again to me, James Wilson from Park Square Barristers, giving a brief précis over an interesting case judgment for which was handed down on the 21st of April in the High Court by His Honour Judge Pelling, Queen's Counsel, sitting as a High Court judge. It's the case of Acorn Finance Limited against Markel UK Limited. I will put the link to that case and two other cases which I'm going to refer to in the YouTube channel. The link to that YouTube channel is in my bio. It's a case dealing with insurance indemnity and fraud largely, and I'll give you a quick précis of the case so that you don't have to read the first 53 paragraphs. The claimant sued the defendant under the Third Party Rights Against Insurers Act 1930, which is now of course repealed by the Third Party Rights Against Insurers Act 2010, which came into force in August 2016. The claimant sued the defendants insured and obtained judgments in 2016 and 2017. Now, the insured was an insolvent company who had previously carried out property valuations. The defendant was the underwriter for professional indemnity purposes of that insured. The claimant's case was that the insured had overvalued a number of properties. The defendant sought to avoid those policies as a result of misrepresentations and non-disclosures made by the insured to them. The main discussion in the case was that the policies were subject to an unintentional non-disclosure clause, and that was this: you are able to establish to our satisfaction that such non-disclosure or misrepresentation was innocent and free from any fraudulent conduct or intent to deceive. Ultimately, the case came down to this: the defendant would waive its rights to avoid the policies, but only if the misrepresentations that the defendant relied upon were innocent and free from any fraudulent conduct or intent to deceive. Now, the judge heard evidence, mainly from the insured, and once the judge made findings of fact about those misrepresentations, there were two main issues of interest in the case. The first was, in the light of the unintentional non-disclosure clause, who was to decide whether those misrepresentations were fraudulent or not? And the second was how to assess fraudulent behaviour in terms of evidence. So in terms of the unintentional non-disclosure clause and its interpretation, you can go straight to paragraph 54 onwards of the judgment. Thereafter, the judgment helpfully sets out the law and approach, in particular highlighting the 2015 Supreme Court decision in Braganza and BP Shipping, and I'll put that link on the YouTube. In short, the court does not substitute its own decisions for that of the defendant's decision maker. So in this case, the defendant via one of its employees had made the decision that the insured was fraudulent. If the court doesn't substitute its own decision, without some interference from the court, the parties would be bound by the term of the contract, which says the defendant can make the decision, and it would be open to the decision maker to make an arbitrary, capricious or irrational decision. The court therefore implies a term into the contract. It has to then assess what term should be implied into it. And the court, in this case, in Acorn, applied the Braganza principles. And it does so by applying Wednesbury and the principles in the Wednesbury case. There was some discussion about the extent to which the Wednesbury principles apply to a decision maker who's not a public authority or a court. But effectively, Wednesbury and Braganza imports two elements into the test. The first is a requirement that the defendant will not take into account matters it ought not to take into account, and conversely will take into account only matters that it ought to take into account. And secondly, a requirement that it does not come to a conclusion that no reasonable decision maker would ever have come to. So that's how the court implies a term into the contract. And of course, that's fact specific and dealing with the commercial realities and what was known to the parties at the time. Dealing with the second issue which was highlighted, that of fraud, the court looks at that when deciding the second limb, when assessing the second limb, of no reasonable decision maker could make that decision. And the court obviously went back to the 1996 decision of the House of Lords in Re H Minors Sexual Abuse Standard of Proof. And that says this: the more serious the allegation, the less likely it is that the event occurred, and hence the stronger should be the evidence before the court concludes that the allegation is established on the balance of probabilities. So that although decisions in relation to fraud in this case need to be made on the balance of probabilities, one needs to look at the seriousness of the allegation and then assess that against the cogency of the evidence or the likelihood that that action would occur. So in this case it was fraud. In Braganza, of course, it was whether the party to the original contract had committed suicide. That was in the circumstances where there was no direct evidence as to how he had disappeared and was presumed dead. Had he fallen off a ship or had he jumped? The last piece of interest in the case is the final paragraph where His Honour Judge Pelling Queen's Counsel highlighted the need for decision makers, specifically in this case in insurance companies, who are assessing UND clauses, that they should be trained to have regard to the Braganza duties. So I hope that's helpful and interesting. As I say, you can watch this video on Instagram. If you go to YouTube, you'll get all the relevant links.